This Monday marks the first day back for the Supreme Court. The justices returning to the bench after their summer break and already grabbing a lot of headlines this session. Here we go. The case of a 20-year-old Muslim woman from Oklahoma who claims she was denied a job at Abercrombie and Fitch, the store in Tulsa, because her headscarf conflicted with the company's dress code there. Bringing in Bob Massey. He is a Fox News legal analyst, and Kent Zimmermann is a legal analyst and contributor to the National Law Journal. Welcome to both of you.
Thank you.
All right, Bob, let's get right to it with you. So the lower court said that Abercrombie and Fitch did not discriminate because Samantha Eloff is her name, didn't specifically say that she needed a religious accommodation. So do you think, or how do you think the Supreme Court is going to rule on this one?
Well, I think when you look at it, companies have the right to set policies. And one thing for sure, Abercrombie is a very visual store. Yeah. When you walk by their store, they have pictures of their models.
It's a smelly store, too.
Absolutely. Exactly. And the bottom line is, Kent and I actually communicate a little bit on this. And, you know, as he said, look, you know, at this point in time, she did not disclose, from what we know as an applicant, some type of accommodation as a result of her personal religious beliefs. So as a result of that, when you look at the evidence that's been presented, it appears as if that Abercrombie is going to have a very good argument in this particular case before the Supreme Court.
Yeah, and Kent, let's take it here for a second. How do you think this decision will impact companies and employers' rights to set their own standards? We're talking about dress code, et cetera. And then beyond that, how will that impact future employees, their ability to, follow their religious practices and get hired at the same time?
You know, Arthel, there's strong feelings on both sides of this argument, and people sometimes get emotional when religion is involved. But I think the points that Bob raised are really important. She didn't disclose that she was wearing this for religious beliefs. They didn't believe she was wearing it for religious beliefs, or so they say. And also, it's hard to see how they could have discriminated against her if they didn't know. I do think, like Bob said, if you're a company, just like the flight attendants have for years, you can hold your employees to very high standards. You could say what their hair and makeup should look like, and that you could say how they could dress. You just can't intentionally discriminate against religion and other protected classes. And so I think that's going to continue to be the way that companies approach this sort of thing.
And by the way, Abercrombie and Fitch has since said that it has required to tell its employees that it can make religious exemptions to what they call their look back. It's kind of their fashion dress code for the sales associates. Go ahead.
And if I may, and I don't know what Kent's thoughts are on this, let's assume, like you just said, they have put this exemption in. I guess, practically speaking, how do we know why they didn't hire that person, even though they put the exemption in or the accommodation? In other words, the process could be inherently, intrinsically defective and discriminatory, even with the exemption, because they could say, well, that person didn't qualify. And I think, you know, that's something you still have to look at also.
Yeah, and that is what's going to play out, I think, in the court of public opinion. What do you say, Kent?
I agree with that. That will play out in the court of public opinion. I think the thing to look at is whether the discrimination, the alleged discrimination, whether it's intentional. If it's not intentional, it becomes very difficult to prove, and it also becomes difficult to prevent. So I think you really need to look at what's intentional, and if there are other things happening, look at those on a case-by-case basis. But it's the intentional discrimination that I think we got to focus on.
Okay, let's move on to another case that's grabbing a lot of national attention. This one's coming from Texas. It's a case over a powerful legal tactic used to combat housing discrimination. So at issue here, there is a fair housing group that claims the state of Texas was approving more low-income housing in black neighborhoods than in white areas, even when, going back to your earlier point, when there is no proof of intent to discriminate. So, Bob, how is this going to play out?
Well, you know, again, as Kent was just talking about intent, this is the problem with this situation. And the question is, if you can't prove that this was intentional, then how do you basically get around this issue? In other words, the question you look at this and say, well, was there some type of strategic implementation that was intended to cause some sort of discrimination in the housing issue? I'm not sure how you're going to prove that if it's not intentional, but in this particular case, they're basically saying even if it's not intentional, if we sort of investigate the way they did it, it's discriminatory. That's a slippery slope.
Well, now, Kent, as you know, this tactic is normally used, bringing the audience back in, normally used in employment discrimination cases. But, you know, to Bob's question, can it be applied to the issues of fair housing?
You know, it's been the centerpiece of an effort by the current administration to try to crack down on what they perceive as unfair housing approaches. But I would just say, how can you say to the state of Texas, as the administration is trying to say, look, you can't take race into consideration as you decide how to hand out these funds for low-income housing, but at the same time, while you can't take race into consideration, you have to be responsible for having perfect symmetry on how the housing that you develop with these funds plays out for the races. In other words, you can't have a disparate impact, the law would call it, on one race over another. I think that puts the state in a very difficult position, and it holds the state to a standard that I think would be hard to achieve. I think that's an issue here.
What do you say to that, Bob?
Well, I mean, I think Kent's absolutely right. You know, look, policies are set up for purposes of trying to be fair in most cases. The application of the policies, the way that it ultimately ends up, is what is always looked at. That's what courts look to in cases like this. So the question is going to be, is there something within this intent? Was it something that they actually designed to discriminate? And that's why I'm saying, as Kent is absolutely on point, and that is, how are you going to hold them to this standard that's showing that, well, even in the absence, there's intent? It's, to me, I'm not a constitutional law guy, but I have to tell you, I think it's a tough issue that the Supreme Court's going to be looking at.
A tough issue, because on the other side of that issue is the fact that the people who are being discriminated against need protection as well from the law.
Yes.
So,
yes.
All right, we will keep an eye on it. Bob Massey, Kent Zimmermann, thanks to both of you for joining us this afternoon.
You bet.
Thank you, Kent. Take care, buddy.